Welcome to the InnoVision Collaborating to Innovate third part, making your collaboration work. So if you joined us in the past, we had covered some other collaboration topics like, do you need collaboration? And if so, how do you get it started? Today, we're going to assume that you were successful at those earlier efforts and that you now are engaged in some sort of collaboration. And the question is, what kind of issues do you run into in actually trying to manage a collaborative effort? And we've got two great experts joining us today to share with us their thoughts and suggestions on how we can do that most effectively. But before we get started, I'd like to invite Amy Robichaud, who's our leader of InnoVision, to share with us the people who help make this possible today, as well as some upcoming events, particularly our call for entries. Amy?
Yes, our call for entries deadline is looming. Applications are due June 30. So if you have an innovation to be highlighted and one that you would like to enter for the 2021 InnoVision Awards, please do so. I will put the link on the chat room. It's a fairly straightforward process. It certainly is not a lengthy process. So please spread that word for within your company and also with other innovators in the state. And of course, we could not be focusing on highlighting and promoting innovation in the state without our sponsors. Our early sponsors for 2021 are Contech Inc., South Carolina Research Authority, Tektronic Industries Power Equipment, Dark Points, Upstate South Carolina, and Velux North America. And we will be announcing finalists in August and then celebrating them in the Meet the Finalists webcast series in late September and October. And then the winners will be announced in November. So stay tuned. It's another exciting InnoVision year.
Excellent. Thank you, Amy. At this point, I'd like to introduce Eric Thome, who's going to be our moderator for today's session, and he put it together, and I'll allow him to introduce our two distinguished guests. Eric, you want to take it away?
Great. Thank you, Michael. Again, today we are in the third of our collaboration series, talking about making your collaboration work. And once you've decided to do it, now what? We'll tackle some real stories about collaboration agreements, governance matters, legal issues, and some best practices managing managing relationships. It'll be in a discussion format, so I'll pose questions, and the speakers will each have a chance to respond and provide examples from their real life experiences working with multiple collaboration clients. And we'll also have opportunities for Q&A. So please enter it into the chat as we go, and we'll have 10 to 15 minutes at the end. So without further ado, I'd like to introduce Hunter Freeman. Hunter is Hunter's an attorney and partner at Byrne Forman in Greenville, South Carolina. He's been doing intellectual property and commercial and corporate litigation for more than 17 years. And he's also one of the board members of InnoVision Awards. Hunter, you can fill in the details probably better than I can. I'll let you give a more full description.
Well, thanks, Eric. So as an intellectual property, a lot of what I do is I help clients leverage their innovations and their branding to keep competitors out of their sandbox so that they can gain and maintain market share. So you can kind of think of me as a modern day moat builder. On the front end, I can assist with the identification and registration of a client's intellectual property rights. And then on the back end, I can help them enforce their intellectual property rights against would-be copiers or defend their intellectual property against competitors' claims of infringement. So I really just try to work closely with my clients to develop an understanding of their business goals and then help develop that moat that would keep competitors at bay. In terms of the practice areas that I work in trademarks, trade secrets, copyrights, patents, and contract and licensing. So that is a lot of what I do. And so I will turn it back over to you so that you can introduce Paul.
Great. Also to join us today, the second of our speakers is Paul Asper. Paul is the Chief Commercialization Officer with the Xeon, which is part of MUSC in Charleston, South Carolina. Before that, he's worked in healthcare and innovation in a variety of roles and levels. Paul and I also know each other personally here in Charleston. I know he's quite involved in our community and our school districts, a number of volunteer levels. And Paul, would you please give us a little bit of your background?
Yeah, will do. Thank you, Eric. And I apologize, there's a little yard work going on outside, so apologize if y'all are hearing a little background noise here.
All good.
Want to just start by saying thank you to Eric and the InnoVision board for inviting me to participate today. And thank you to the panelists from the first two sessions in the series. I learned a lot from those two sessions. If you haven't watched them, go back and check them out. Jim and Jeff and Susie and Andy are tough acts to follow. So thank you all for those sessions. Like Eric mentioned, I currently serve as Chief Commercialization Officer for the Zucker Institute for Applied Neurosciences, or Xeon for short. We are a 501c3 nonprofit accelerator that is, like Eric mentioned, embedded in the Medical University of South Carolina, staffed by medical device engineers, intellectual property specialists, and business development folks like myself, and all oriented around our mission, which is to impact patient care through new technology, and to do that by helping scientists and clinicians turn raw ideas into real life medical technology that's impacting patient care. And that's also generating economic return for our inventors, investors, commercial partners, for MUSC, for our state, and for our organization Xeon, so that we can serve even more inventors and more patients. In the context of the panel today then, and to give you some sense of the place from which I'll approach today's discussion, where we're talking about how to make your innovative collaboration work. At Xeon, we're at a place now, 9 years in, where we get to evaluate dozens of medical device concepts each year, and we've helped clinicians and scientists to secure dozens of issued or pending patents, millions of dollars in R&D funding, multiple exclusive licensing deals with industry-leading medical device companies, and several FDA approvals and commercial device launches, and on track to do 2 to 4 new technologies every year, and to continue to have an even bigger impact on patients as we go. And our ability to do all of the above is highly dependent upon and doesn't exist without our ability to successfully form and manage collaborations with innovative partners across the spectrum, including scientists, clinicians, med device inventors, governmental agencies, like the incredible Office of Innovation at SC Department of Commerce is one really recent example and current example for our organization, like MUSC's Technology Transfer Office, the Foundation for Research Development, with mission-aligned philanthropists and early-stage investors, engineering and co-development vendors and partners, and ultimately with medical technology companies and commercialization partners that range in size from startup to middle market publicly traded companies. So at Xeon, we are collaborating to innovate every single day, and with stakeholders across the spectrum. And that's a lot of the experience that I'll draw from in my comments during the discussion today.
Excellent. Thank you. So we have a handful of questions, and Hunter, I'll ask you to start us off. Once you've agreed to collaborate, what's the next step?
Well, the overarching answer to that, I would say, is just manage expectations. So when you're starting off, you need to, I think one of the first questions that you need to ask is, who's bringing what to the table? Because that's going to determine who wants what and who has what bargaining power. So typically there are a handful of things that people will be bringing to a collaboration. First, and probably most important, is money, and then the know-how, the technology, and the distribution channel. So you need to figure out what is your contribution to the to the collaboration, because at the end of the day, that your contribution is going to have a direct effect on what you can claim out of it and what you can negotiate your role is going to be. I would say one of the very first things that you also need to consider, which is part of the who's bringing what, or what are the confidentiality concerns. For example, what is going to be the existing intellectual property that you're bringing to the table? And you need to determine if there is existing intellectual property, is that something I'm willing to share? Is that something that I'm willing to basically assign or donate to the collaborative organization or invention? And then what about, what about the new intellectual property that we jointly develop? And then what about the future intellectual property that might, come down the road after we've got the first iteration of the invention? Then I think once you've got kind of those two major points kind of figured out, you can then start thinking about, well, what are the best legal structures that can help us really propel this forward? And two of the probably the most common legal structures that are used would be a holding company. So for instance, if you are a group of individual inventors, you could simply create an LLC, and each person can have a membership in it. And then your ownership and your rights are determined by the operating agreement of the LLC or the incorporation. Those are all types of things that you want to determine is what type of legal entity. But if you don't, and then if you are already an organized entity, so if it's two businesses that are coming together, oftentimes those businesses will form a third business in which the members are not actual natural persons, but they're instead juristic entities that this company owns 50%, this company owns 50%, or you can really change the ownership interest however you want to. If you don't go that route, the other next most common way to deal with this is just through some sort of joint venture agreement where the companies or individuals just agree to a pretty detailed agreement that says, okay, this is what I'm bringing, this is what we're going to treat it as, and this is what I'm going to get in return. So it maps out all of the things. And the key to those agreements is playing the what if game. What if this bad thing happens? What do we want to have happen? What if this good thing happens? What do we want to have happen? So basically, you need to kind of try to go through all the what ifs that you can. The last two things that I would say that under either one of those, whether it's a holding company or a joint venture, is you want to start thinking about tax implications that it may have on you in terms of your contributions and what you're getting out. And then finally, termination considerations. What happens at the end of this collaboration if all goes well, or what happens if one of the collaborators wants to get out early? What is the triggering event that would spark the termination? What is the process by which you terminate? And most importantly, who gets what when you terminate? So I would say that those are some of the there's a lot of questions you got to ask, but those are some of the main legal questions that you would want to consider when just starting out with the venture.
Okay, that's great. Simple question with a long and complex answer and a lot of bullet points for a lot of deeper conversation. Paul, from your experience, what have you seen once you've agreed to collaborate? What do they do with the next step, or any stories around it?
Yeah, it's really aligned with a lot of Hunter's comments, and kind of lumping it into two big buckets, I think. For me, number one, it's all about clarity. And I'll kind of like bullet out a few things under that. And then the second was like get help. So under that clarity bucket, and again, I'll try to keep this as like, in a lot of my comments, kind of as, specific as possible, but still broad enough that they'll hopefully be relatable to people across many different types of collaborative structures. So, on the clarity front, if you're not already, hopefully you are by this point. But if you aren't already, this is the time to get clear about what, like Hunter said, what do you want out of this collaboration? What does your partner want? What are each of you bringing to the table, whether that's intellectual property or cash or manufacturing or access to new markets or marketing or other expertise? And what are your expectations of each other? How does all of the above inform how you'll formalize your collaboration? Typically, like Hunter mentioned, in the form of some kind of contractual agreement. So there's a bunch of different flavors of that. So, but it's like, is this more of a vendor type of partner where they'll help you move your project forward by providing engineering or other expertise, and you pay them something and then you part ways? Or is this a longer term collaboration partner who plans to have some ownership and stake in the end product that you're producing, and maybe even manufacturing and or marketing together? Is this a company to whom you plan to license or sell your innovation? If so, do you plan to stay involved and or keep some ownership and have a stake in the long-term success? Or are you selling your innovation and moving on? Those are just a couple of many, many potential collaborative partnership flavors. But the key to me, again, is like, get clear about what each of the partners want out of the collaboration, what you're each bringing to the table, like Hunter said, what you expect of each other. And then, like Hunter said, how that will be memorialized in your collaboration agreement, whatever form that takes. And Hunter mentioned this, I think, a little bit too, like from a practical standpoint, there's some cases, especially in longer term, bigger, higher risk partnership, where it's really helpful, even before you've decided to be partners, and certainly at the point where you're talking about or moving towards a definitive agreement, to pre-negotiate some of the key stuff in the form of a letter of intent or a non-binding term sheet, something that allows you to get on the same page before you, no offense, Hunter, get the attorneys involved, and that allows you to save a bunch of time on the front end, allows you to potentially save a bunch of lawyers' fees if you can get aligned on some of those key terms before you jump in on the bigger task of creating that full binding agreement. And then number two, and get help. This one, it feels intuitive, but it's like so worth explicitly saying, if you haven't structured and negotiated collaboration agreements before, find people who have and who are willing to help. And ultimately, unless you are an attorney, I would strongly encourage everyone who's at that stage to find a great attorney, someone who can be a resource to you in terms of helping shepherd, negotiate, finalize your collaboration agreement, especially if you don't have experience writing and negotiating partnership contracts. And by the way, I'm not talking about calling the number of the personal injury attorney whose picture you used to see on 18 different billboards every morning on your daily commute, when the daily commutes were a thing. No offense to personal injury attorneys, but the point there is, like, just like everything else, people who do something a lot and regularly and have a bunch of experience are often better at it than people who don't have as much experience doing it. So really encourage you to seek out someone who has specific experience in the space in which you're looking to collaborate. So if it's an intellectual property heavy type of agreement, find a great IP attorney. If you're going out and raising capital from private investors, like, go find an attorney who has a bunch of experience doing those kind of agreements and those kind of deals. And then the last point on that get help thing, which Hunter mentioned, and I think is just so key. One of the things that sometimes we don't think about because it's not fun, like he said, is when we go into these collaboration agreements, like, not only what happens when things go well, but what happens when things, if they don't go as well as we planned or don't go as quick as we planned. Man, that's one of the places where I've leaned so heavily on wonderful counsel over the years to help you just think through what are those potential situations that you might want to anticipate, and just eliminate as much ambiguity as possible with your partner going into this thing about what happens if it doesn't work out, unfortunately, but hopefully, what happens if it's wildly successful.
Very good. Very good. Thank you. Well, you guys both alluded to this. For the next question, Hunter, how does funding and the funding sources impact ownership and the collaboration?
So the overarching point that I would say there is, she who has the money expects the power and control, right? And so where you get your money from is going to kind of dictate a lot of terms, or at least who you're going to have to answer to. So a couple of the points that I would bring to your attention is be aware. I'm not going to say be wary of, but just be aware that when you're dealing with government funding, there is more than just a nominal, but there's a decent risk that you will have some sort of, you'll have to deal with a government ownership issue, because there are certainly federal procurement codes and things like that, which gives the federal government the right to these inventions when they, when their resources are being used, when one of their employees is being used, when their money is being used. So don't think that anything that the government is giving you is just completely for free. That's not how it works. The government will expect something back from you. That's not to say that always they're going to own all of the patent rights or all of the intellectual property rights, or even any of them, but that is certainly a consideration that you need to think of if you're looking for government funding. I would say the same goes for universities. Universities typically, even if they're not falling under the same federal procurement codes, they very much like to own the inventions with which they are involved. So before you get involved with any sort of state agency, just at least ask the question, what do you want in return for this money? What kind of oversight are you planning on having? What kind of ownership interest are you planning on having? So it's all the same. Get clear very early. Another source of funding that people often go to is private equity. Just know that in this case, there's certainly no such thing as a free lunch. Most of the time, joint, whether they're venture capitalists or anything, they're going to want some sort of ownership interest in something. And most of the time when you're going to a venture capitalist or private equity, that's when you're going to use the holding company, because they don't necessarily want to have an ownership of the patent or the IP rights. But what they want is they want a company in which they can have a certain ownership interest in, and they want to be able to review the bylaws and the operating agreement and know exactly how things are going, because typically, again, going back to the get clear, and one of the things you want to be clear on is what are the exit strategies of all the parties involved. I can tell you, private equity, they typically have a fairly short exit strategy. I mean, they want to get you successful quickly, and then they want to get out, because most of the things I've heard are that 80% of the investments made by angel groups and other private equity groups fail. So they really have to hit home runs on like 20% of what they do. And so they want to get that money in and out as quickly as possible. So then the final way that people get money, or another typical way, is they fund it themselves. And that leaves the most room for negotiation in terms of what is being purchased with that money. Because if you're the one with the know-how, the more tallies you have in your column to match the money tally in their column, the more negotiating power you're going to have. So if you have the know-how, the technology, the customers, all that, but you just need some money, then you're on a more equal footing. But the money is a big check mark in that person's column.
Yeah, great. And Paul, with everything you have rolling through the FRD, or I assume that has implications for you as well, the funding.
Yeah, absolutely. And would just really echo a couple of the points Hunter made, and share one example that where I've seen this go south. Again, to me, it goes back to that idea about being clear about what each partner is bringing to the table and how that impacts not only ownership, but expectations for who will own what share of the intellectual property and the profit along the way, and the end product, assuming this is wildly successful like we all want it to be in the collaboration. And unfortunately, I've seen cases where there wasn't great communication on the front end, and two or more great, well-intentioned partners plowed ahead with the exciting work and got pretty far along, and at some point looked up and realized that their expectations about who would own how much of the end product of the collaboration was pretty wildly divergent. And where the expectations were really divergent, and where that miscommunication and misalignment ultimately caused the collaboration to dissolve. And to me, that's just a real case study, and like something that's really totally preventable with good communication and clarity on the front end about everyone's expectations. And is this the kind of, based on everyone's expectations, can we find a place where, we can be aligned on how that looks as we go?
Great. And Jerry, I appreciate your comment in the chat relating this to other types of relationships. This is a relationship. And then once you've had some of that clarity and the conversations, who's bringing what, now you have to manage and maintain this relationship over time. Paul, what do you see as challenges and best case practices for this?
Yeah, probably two big areas again, and I'm gonna continue to echo some of those themes. One, it goes back to getting the contract right, and being as clear as possible around who's doing what by when, how you'll interact with each other, who makes decisions, how are decisions made. Do both partners need to be involved in every decision, or does one partner or both or all of them have the ability to make unilateral decisions that could impact the collaboration? Will you have a regular cadence of management or working or board meetings? Who's on the board? Will one or both partners provide written or other reports or updates or metrics on some regular or as requested basis? The other thing that's really helpful about memorializing as much as possible on the front end is that you're far better protected again in the really unfortunate event that your collaboration partner turns out to be not as awesome of a partner as you had thought or hoped they were going to be, and now you have clear rules of the road that you can point back to and use to hopefully hold your partner accountable and ideally get the collaboration back on track, or in the worst case to terminate it and go your separate ways. And then number two is sort of the softer part of it. That's maybe the most important part. That first part's kind of the formal, contractual part of the relationship. But and like I said, I'm a big fan of formalizing as much as possible on the front end because I think it helps eliminate so much ambiguity down the road. But certainly the other uber important part is investing in the relationship and ensuring that you're allocating your capacity, your team's capacity, to ensuring that the collaboration is resourced appropriately, that it's being given the right amount of attention, that you're holding yourself and your team accountable to the commitments that you made to your partner, that you and the right members of your team are having regular touch points with your collaboration partner, that you're doing this in person now that we can do that again, which is really fun. It's just partnership 101 stuff, but it's so worth re-emphasizing the importance of not kind of signing this agreement and then checking in 4 months later and expecting that everything's just going to be running smoothly. It's all this sort of normal relationship stuff applies. And also, I can't re-emphasize enough, demonstrating also to your partner that they can count on you, that they can rely on you to deliver on the commitments that you made, in the same way that you want to count on them to do the same.
That's great. And it sounds like a lot of juicy examples there to back some of that up, which we'll get to. But Hunter, anything else to add to as the relationship goes over time, how to manage that?
Yeah, so the first thing I wanted to do is follow up a little bit on what Paul said. So the reason that coming up with an agreement that memorializes everything up front is so important is because now you're making decisions when everyone is friendly and the money is only theoretical. When the money's real and tensions are high, you can imagine the decision-making process gets a little bit more tense. And so another part that I wanted to follow up on is the decision-making process. So if you need to, in some cases, not always, because sometimes the deal will be that there's never a tie, but to the extent there is a tie, you have to have a tie-breaking mechanism so that when two partners or three or whoever can't agree, then there's some way to break that tie. But beyond that, I would say that the two most important things to me would be good record keeping and good communication. And the reason that I think good record keeping is very important is I'm thinking, obviously from an IP perspective, is it helps determine conception dates of the invention. And this is important for, logistically speaking, milestones. If your funding is dependent on you hitting certain milestones, you now have your lab notebooks and your invention disclosures that help you back up your claim that your milestone's been hit. But from a legal perspective, it can be important too. We used to be a first to invent country. Now we're a first to file. So priority dates aren't as important, but there's this thing called derivation proceeding, which means if someone truly tries to steal your invention and they file a patent before you have a chance to, you can go back in and show, no, actually, I invented this first, or we invented this first, and they essentially stole this from me. But as you can imagine, that's a very fact-intensive inquiry. And the more records you have for that, the better off you're going to be. So protecting your invention, again, worst case scenario, it's just good to have it. The second reason that record keeping is important is it determines who's going to be an inventor. If you decide to go the patent route, you have to name everyone who's an inventor. And we can talk a little bit later about, well, we can talk about it now. The inventor test is basically who conceives, who assists in conceiving part of a claimed invention. So you'll get into looking at first what the claimed invention is, and then you'll look at whether or not that you had a part in that. And so again, these notebooks will help determine that. And they also help with the progress timeline. So those are the reasons I think that record keeping is important. As far as communication, again, this is partnership 101. But expectations change throughout the course of the deal or the relationship. So just letting people know what the expectations are, especially when things take a turn that you weren't quite expecting. And that could be a good turn or a bad. Like maybe the invention is working in something, a field completely different than you initially thought. What do we do about that? Our original, it looks like this is going to be a success, but not in the field we thought it was going to be. How do we handle that? Cash flow, keeping up and communicating, here's what we need, allocation of resources. So things of that nature, I think it's just a good idea to keep records of and to communicate regularly. The last thing that I think is important, and I'll get more into this when we talk about examples of why things either worked out or failed, is you have to have a system of monitoring and or enforcing. So holding people's feet to the fire, making sure they're doing what they said they were going to do, or doing what they're expected to do, or getting things done in a timely manner, to make sure that one, they're being a good partner, and two, you're being a good partner. If they're not, what do you do? So thinking about those types of mechanisms. So those are kind of the things that I think that you would do to try to keep everything moving on the right foot and in the right direction.
Okay, great. There's a comment Jim made asking and kind of blending in some of the previous questions about funding sources and ownership. And for the federal government contracts, having limited rights and government purpose rights clauses, is that the same? And is that true for grants as well, since grants are an assistance mechanism and not a procurement instrument?
So I think you're going to run into that, and Paul might deal with this on a more regular basis than I do. But I think you run into that less with grants, but I still think that it can be an issue, so that you need to look into that. But I will say I'm not an expert on grants.
Paul, do you know?
No, I don't know the answer to that question either.
Okay.
I would like to take a crack at Dave's question though, if I could, Eric.
Please. Dave is asking, like any relationship, trust is an important component and some best practices beyond the written contract.
Yeah, and I'm sure Hunter could offer, probably everyone on here could offer some ideas too. In my experience, it's some of the stuff we talked about, just some of the relationship 101 stuff of being present, like in any relationship, and communicative, and doing that regularly. And also demonstrating performance on your part to build trust, to demonstrate that it's not just me holding you accountable, it's me performing and living up to the expectations of this partnership. The other thing I'd kind of say that sort of overlaps with some of that is just, I don't know, I call it kind of having this partnership mindset of, despite best laid plans, what sometimes hits the fan, and at the very least, unexpected situations arise that you didn't anticipate, that maybe the contract didn't anticipate, and now you have to figure out with your innovation partner on the fly. And if that's a partner that you want to continue to work with, there are times when it makes sense to sit down and rethink how to go forward in a way that makes sense for everyone. That doesn't always work out, and sometimes it certainly makes sense to unfortunately even part ways as amicably as possible. But man, there are plenty of times when, in the spirit of kind of building trust and being a great partner, with a little creativity and having that kind of empathetic partnership mindset, where both parties can figure out a path forward that might even involve renegotiating contractual terms, and that might be the best in the end for everybody. And I do want to be clear on that point that, I don't suggest that you roll over by any means. There are a lot of cases where you want to stick to your guns, and man, there are a lot of cases, unfortunately, where you might even want to deploy every legal option at your disposal to protect your innovation and your business or your intellectual property. But I'm also a big fan of not starting at the other side of it, of a place of, is if this is a partner I want to work with, who is potentially giving it everything they could, and things just didn't go quite as planned, but potentially everyone's still better off figuring out a way forward together. That to me is where having that kind of partnership mindset can pay huge dividends, both in your current partnership and like long-term potential for success. Also in terms of just reputation and brand, and being seen as an individual or an organization that people want to work with because you're trustworthy, because they know you're firm but fair, that you drive hard, but that you're empathetic and reasonable, and that you act with high integrity. That's the stuff that's not necessarily written in the contract, but it works, and it goes a long way towards having success in business and relationships and across the board.
That's great. Well, both of you have had a lot of experience seeing clients and people and companies, institutions. So while maintaining client confidentiality, what are some examples? What have you seen? What are the stories of what's gone well and others where it hasn't worked out so well? And what did you learn from it? Hunter, do you want to go?
Sure. So I can think of two examples off the top of my head. And the first one dealt with kind of the lack of clarity over inventorship and ownership and confidentiality concerns up front. So I had a client who was not a client at the time, thankfully, or else I'd probably be getting blamed for this, who was partnering up with another entity and basically started to download everything that they had, and it didn't sound like they had a very strong confidentiality agreement in place. And they certainly didn't have any sort of written agreement as to who would own any sort of new application, because my client had an application and he was trying to get into a new industry. And then the partner kind of took it and run and cut my client out. And so they ended up in a federal lawsuit over who owned the patent rights to this new application of an existing technology. And so really, this was an example of two things. He who has the money, wants control. And unfortunately, my client wasn't the one with the money. So the other party just figured, well, I've got all the money. I should own all this. And I'm the one, footing the bill for this. So it's mine. And then it was also an issue where they hadn't had some of those frank discussions about, okay, well, what is going to counterbalance the fact that you've got the money? I've got the technology and the know-how. And so, but most important to me is be sure, like Paul said, pre-negotiate some of these things before you start truly talking to one another. And the most important in my mind is the non-disclosure agreement, before we get into anything confidential, you've got to sign this that says you're not going to use, disclose, or take this from me. And apparently that was not done, and it cost a lot of money to rectify. The other example I can think of were two very large companies. And so the bargaining power was fairly the same. And they had decided on some field of use restrictions. One company was going to use the collaborative invention in one field, and another was going to use it in the other field. The problem was that there was not any sort of enforcement mechanism, because one of the partners, one, not only went outside of their field of use, but two, started filing applications on all these new things that they were doing that directly related to the joint collaboration, but happened after kind of the collaboration was considered to be over. And so again, it came down to, well, that future IP that I was talking about, there's existing IP, there's the new IP that we create together, and then there's future IP that maybe one or the other comes up with as they use the invention after the collaboration. And there was no understanding or agreement what was going to happen with that future IP. And so there again, this one was actually an international lawsuit that was filed under the Hague Convention, and because it was a Swiss company. And so you can imagine that was a very complicated, very expensive lawsuit with two very large companies, and it was not fun for either side, I'm sure.
Right. There's no winners in some of those cases. Paul, what about you? What examples of things that worked well and things that did not?
Yeah. I think there's four kind of key buckets, I'll call them. I talked about partnership mindset as sort of one of the big ones, but kind of in the context of like themes that are sort of mirror images of each other, in that they're themes that in my experience, that have been present in the collaborations that I've seen that have worked in, or that appeared to have the greatest chance at success. And then the corollary that one or more of these pieces was missing in those collaborations that I've seen that have failed, and or that have appeared to be the most at risk. And I already talked about partnership mindset and how important I think that is. And when that's not present, it's not fun, and it can go south really fast. Particularly like we're innovating here. People innovation by definition is really uncertain and risky and hard, and you can anticipate try to anticipate everything you possibly can, but there's going to be stuff you can't anticipate. So that's a big part of why I think that's so important, and kind of goes back to like my first one, and it goes back to the first couple of sessions in this series, which is like, start with the right partner to begin with. The number one thing you can do to ensure that your collaboration works well is to put the time in on the front end, to do your due diligence, to be patient when you can be, and not rush into a collaboration when you don't need to vet potential partners, to ensure that your goals and values also are aligned, that your potential partner is high integrity. And then the reverse is also true, that one of the best ways to put the success of your collaboration at risk is to not put in the time on the front end. A really specific example, or a type of situation that I've seen, and I know others have, is where maybe a company is looking to acquire a technology or another type of innovation to basically put it on the shelf, or maybe it's really kind of speculative. They want to have it in their portfolio to maybe do something with it down the road, that's not necessarily ill-intentioned. That might be a good business choice from their perspective. But if you're the inventor, certainly from a Xeon perspective, where part of our mission is to help researchers and clinicians get their ideas back into the hands of clinicians to impact patient care, that's very inconsistent with a partnership that we would be looking for, and we would walk away from that. And there's probably a lot of other inventors out there, or companies out there, who might do the same if they were clear about what their potential partner's intention was. So again, that's one really specific example of kind of right partner. But I think hopefully it's illustrative around this idea, like, choose your partners wisely, especially when you're entering into a long-term partnership. Number two, again, just total broken record on this, is just, right clarity. And the collaborations that I've seen be successful, they were typically built on a clear understanding of the goal of the collaboration, what each party is bringing to the table, who's doing what by when, what happens when we're successful, what happens if we aren't successful as fast as we'd planned or at all. And that feeds into the one we've talked about. The other one we've talked about a bunch too is right contract. Again, you can't anticipate everything. And with contracts, even the long-term ones, you want to be careful about getting carried away and trying to write every possible situation into the contract. And all of a sudden you have this unruly 200-page beast that no one wants to sign, and it kills the deal. But that said, the collaborations that I've seen work well were those where the partners had done the work on the front end to be clear about what they wanted to accomplish. And then where they also did a good job of translating that spirit of what they wanted to do with the partnership into clear contractual language that memorialized the collaboration's objectives, who does what by when, etc.
Well, you talked about there about finding the right partner to begin with. And Trey asked an interesting question in the chat. Do you have advice, Paul, on how corporations can engage in exploratory discussion with research institutions? How do they engage for potential opportunities for collaboration?
I'm reading it again just to make sure I got the context right. Yeah, so from the corporation's perspective, got it. How do you engage most effectively in an exploratory discussion with a research institution? Yeah, we do this all the time. That's a big part of my day job, is engaging with medical device companies specifically who are looking to acquire new technology to add to their portfolios. And the technology that we're talking about is coming out of the Medical University of South Carolina in this specific case. So Trey and others who might be interested, from my perspective, there's a bunch of different ways to answer this question, but I think one is, be open to the conversation. Two, if there are particular areas you're interested in, find out who's doing interesting work in that space. I know there are a lot of companies that I have conversations with regularly, often sometimes when we don't necessarily have something that might be a direct fit, but it's to kind of check in regularly, see what's going on. The other thing that I find really helpful, being on the sort of research side of it, is understanding what portfolio areas companies are interested in, so I can keep an eye out for that particular type of opportunity. So to the extent that you have the ability to kind of communicate that to research institutions, to contacts you have, that's super helpful. I know if someone's looking for a particular type of medical device, when that pops up, they're going to be the first person that I call and talk to. And those are probably some of the big ones. I'd love to think about that some more, and please feel free to contact me if there's any questions that would be helpful to talk about offline. Yeah.
Okay, great.
Thanks, Paul. That's helpful.
I want to open it up to general Q&A now, and we had one in the chat from Amy, and maybe Hunter, let us know. Do you require NDAs for initial discussions, or at what point do you require an NDA?
That might have been more to Paul. I mean, obviously,
Okay.
my answer is sure, yes. As soon as you're going to be talking about something, get an NDA. But I'll let Paul answer about at what point the university requires one.
Yeah, in our particular line of work, we're happy to have an initial conversation outside of an NDA often. And I do that regularly. Our team does that regularly. If it depends somewhat on the stage of the technology. So the technology that it's very early, we haven't filed any intellectual property yet. We're going to hold our cards very close to the vest in any conversation outside of a non-disclosure agreement. If we, on the total opposite end of that, we have technology where we have issued patents, we have really strong intellectual property portfolio already built around it, I might be much more comfortable sharing a lot outside of NDA, particularly since a lot of that stuff is now in the public domain. But there's definitely a point pretty early on where I look to move to non-disclosure agreement if people are really serious about evaluating the technology or evaluating a collaborative partnership.
Great, thank you. Any other questions? You can unmute yourself or put it in the chat.
Hey guys, Jerry Plesky, just a curiosity question on, other common traps that things go wrong. Yeah, I've seen businesses where they think titles mean something like, well, I'm president, I'm CEO, we agree to that. Do you see that happen where people think they have agreements and then get in hot water?
Hunter, do you want to take a crack at that one?
So let me make sure I understand the question. Because you're letting the title get in the way of things, that is. Can you just repeat the question for me?
Right. In other words, I feel like sometimes owners or partners confuse titles for having legal authority. Is that a common trap?
So from a legal standpoint, like from the signing of the contracts, that it's always best to one of the things I think that these collaboration agreements should have is they should appoint certain points of contacts for each party. And then you can have multiple ones, like on technical side, on funding side, on whatever, but you appoint a joint venture partner A contacts and partner B contacts. That way you know who's in charge of making those decisions, and the other party can rely on that. So I think that takes away some of it. But the other thing that I think that goes to where I've seen it is that people rely on their titles and thinking that they are now inventors just because, well, I'm the CEO of this company, therefore I should be named an inventor. And so I alluded to it earlier, but I wanted to go into it in a little bit more depth about the difference between inventorship and ownership. So an invention for patent purposes has a two-part test. You have to conceive of the idea where you have enough information where you have all aspects to where someone could reduce it to practice without undue experimentation. And then the second part is, can you reduce it to practice? Whether that doesn't necessarily mean a physical prototype, but a drawing or anything like that. Now, inventorship, it really just goes to, has an individual made a significant contribution to conceive the subject matter of one claim. And so or two or more persons have they done that. So the important part about the joint inventors is that you can be joint inventors even if you work at different times, have different roles, contribute different amounts, and different subject matter. The inventor does not need to contribute to the entire invention or all of the claims. And the contribution just means, when I use significant, that just means something patentable, not just saying, oh, well, it should be blue or it should have a handle on there. But another thing is, one of the classic examples is title has nothing to do with whether or not you're an inventor. Doesn't matter if you are the project manager, if you are the CEO or whatever, you need to pass that two-part test. And why is that important? Because each inventor, unless there's a written agreement, an assignment, has an undivided interest in the patent. And that's where ownership initially vests, is in the inventor. So that means if, Jerry, you and I are the two inventors and there's no other writing between us, I can go out and do whatever I want with the patent. I can go make it, use it, sell it, license it, any of that. And I don't have to give you a dime for any of my efforts, but you can do the same. So if you leave someone off as an inventor, and then obviously if you don't think they're an inventor, you don't have them sign the assignment, all of a sudden you've got this rogue person out there who might feel jilted that they weren't named as an inventor, who can then license, compete, do anything they want with this patent. So you don't want that. You want to identify all the inventors, and plus it's another way that you can get your patent invalidated if you intentionally leave someone off. But that is now the CEO might say, I'm the owner because I'm the CEO, and we've structured the deal that my company is going to own a certain amount of it, but the CEO is not necessarily going to be an inventor. So that's where I have seen titles get in the way.
Thanks. That's really helpful.
Great. Well, we're closing out to the top of the hour. I want to give our speakers a chance for any last statements. And for a lot of these ideas, there's probably a lot more homework and resources for people. So any advice or, how to find you if you'll have other questions. Hunter?
One thing that I would go echo on Paul's part is I think picking the right partner and doing the homework up front is probably the most important thing that you can do. And when picking your partner, I would say try to pick one whose interests aren't zero-sum competitive with yours. Try to find someone like you're dealing with a customer or someone who you're developing something for. And the reason being is where joint venture agreements get really sticky and have the biggest chance of blowing up is when you truly have a joint ownership of an invention, because that's just a really tough thing. In fact, on both of the examples I gave you, there was this joint ownership thing. So if you can figure out someone who doesn't necessarily want to own the invention with you, but maybe just wants a license to the technology as opposed to ownership, I think you're going to cut out some of the tension between you. But if you are going to have a true joint ownership issue, I think looking at things like cross licensing, so that I have to pay you for all the sales or a percentage of all my sales, and you have to pay for a percentage of my sales, or having field of use restrictions so that we're not competing in the same space. I just think that if you can take the zero-sum nature out of the partnership, you're going to have a lot less problems come up down the line.
Great. Paul?
Yeah, I just wanted to say thank you, I guess, for being here today. Thank you to Hunter and the group for great questions. I put my email address in the chat. It's asperp, A-S-P-E-R-P @musc.edu. Please feel free to reach out anytime. In addition to always being on the lookout for mission-aligned philanthropists, grantors, and investors, we're certainly always love to help in any way that we can innovators in South Carolina and beyond if we can be of service. So please don't hesitate to reach out. Really fun to be here with y'all today.
Great. Well, I appreciate your time, Paul, and your time, Hunter. It's been fantastic to have two experts in innovation and collaboration come together and share some of what you know. So I'm going to pass it back over to Michael to close us out, or to Amy if she wants to make another plug for applications.
Well, thank you, Eric. Thank you for pulling this together, and particular thanks to Paul and Hunter. Great job pulling in a bunch of ideas. I never cease to pick up a few more ideas, even though when you think you know a particular area, it's great to have some practitioners bring to mind some things that you hadn't even thought of. So that's been wonderful, and I'll echo Amy's comments regarding entries. The core of the InnoVision program is to acknowledge and recognize innovative activities in the state, and the only way we can do that is if people let us know about them, and they do that through the entry process. And so it's the deadline for that's coming up here in the next week or so. So we really encourage you to go to the InnoVision website, which is in the chat area, and nominate someone or nominate yourself. That's also equally workable. Any last words, Amy?
No, I think that's it. Enjoy the afternoon.
All right.
Paul,
thank
be
you all
careful.
Thank you all for joining us, and we look forward to seeing you at a future event.
Thank you so much. I should have said that earlier, but thanks for having us. This was a blast.
Mike. Enjoyed it. Thank you.